Hi, I'm attorney Gregory Dell, and today I'm here with attorney Cesar Gavidia. Hello, Cesar.
Hey, Greg.
And today we are going to discuss bad faith disability insurance claim denials. Now, Cesar, a lot of times claimants call us and they say, my insurance company acted in bad faith, and there's a lot of things out on the internet, a lot on the media about bad faith, but I don't think a lot of people understand what bad faith is and what that actually really means. And first off, we should say that there is no bad faith in terms of if you have a policy that's governed by ERISA. And you can watch some of our other videos on here about what ERISA is, which is the Employee Retirement Income Security Act, to determine whether or not your claim's governed by ERISA, which is usually the employer-provided policy. So we're really focusing here on the individual disability policies. But when you talk about bad faith, which I prefer to call unreasonable claims handling tactics, because that's really what bad faith is. It's about whether or not a disability insurance company acted unreasonably. And you know there's only a few states that even allow for bad faith claims to go forward. So one of the most common areas for bad, or one of the most popular states for bad faith, I should say, just because of the population and because of the pro-claimant laws, is California. And obviously you do a lot of work in California as well as other states. But what is it usually criteria for whether or not a claim reaches the level of bad faith? Because certainly it's not just they denied my claim so they acted in bad faith. What is it from your experience that raises the flag to say, you know what, this may be a bad faith claim?
Well, Greg, as you know, a claim requires proof of loss. So that's the claimant's responsibility once they decide they're going to file a disability claim, is that they have to provide the insurance company proof of loss. There's usually a certain amount of time they have to do that. And most claimants, when they apply for disability insurance, they submit their proof of loss within a particular period of time. Now, once that proof of loss is in, the insurance company should have a reasonable amount of time to evaluate it and to determine if the claim is a claim that they should pay. In my opinion, an insurance company is acting in bad faith and acting unreasonably or unconscionably when they receive that proof of loss, and when they intentionally, or it doesn't even have to be intentional, it could be just grossly negligent perhaps, or negligently delaying it for no reason.
Right. I think an important thing to point out about bad faith, and the case law says this in a lot of different jurisdictions, is that you don't have to have an evil motive. You don't have to have the intent to want to act unreasonably. But if your actions represent unreasonable conduct, then you could be held accountable for bad faith. But the issue that you were just discussing was one issue of bad faith, which is timeliness.
Right.
And so I think usually, what's your understanding as a reasonable time period for a disability carrier to get back to somebody with whatever the communication is?
You know, we get that question a lot. When can I expect my benefits to begin being paid? And most policies have a particular elimination period, which means that they have to wait a certain amount of time before benefits can begin. It could be 30 days, 60 days, 90 days. I think that anywhere between 60 and 90 days, as long as the insurance company has all the information that they need, all the medical records, all the financial information, or whatever else they need to appropriately review and determine the claim, within 90 days they should have a decision, a determination. Beyond that, it's really walking that line very closely.
I mean, we know from working with many of the fair claims practices experts out there, bad faith experts, about it's all about a reasonable time period for even, you just mentioned an example of when someone initially filed, but what about an ongoing claim when you send a letter to the disability carrier? Usually, from my understanding, that the carrier has to respond within a 30-day or even a 15-day period under some statutes.
Right. Those are statutory guidelines that are set forth by the insurance departments of various states, which are there to protect people and there to make sure that the insurance companies are acting in a reasonable and appropriate manner. So if they're exceeding those time limits, I think those are red flags right there that should go up for the claimant, and they should say, look, why is this happening? Why is the insurance company not responding timely? Or if a lawyer is representing that claimant, write a letter, call the insurance company, what's going on? And if there's like a habitual or consistent delay, and failure to respond, I think that at that point there's cause for legal action.
Okay. So timeliness is one of the issues. It's candidly not one of the reasons that we usually bring a bad faith claim because of the fact that they didn't respond timely. It's just another piece of the puzzle to say that you didn't act reasonably. But I think the heart of every bad faith claim comes from the disability carrier's failure to conduct a thorough investigation. What are some examples from your experience of where you would think that a disability company fails to thoroughly investigate the claim and therefore should be held accountable for a bad faith action?
Yeah. Let's look at the medical aspect of a disability claim, because as we know, every disability claim obviously has that medical criteria that needs to be met. So if the claimant's going to be asked, who are your doctors? Where are their offices? We need to get information from them. If the insurance company sends requests out, and then doctors are busy, they have busy practices, and sometimes those requests aren't met, within a week or 2 weeks. The doctors should have a reasonable time. So that shouldn't be held against the claimant. And the insurance company should continue to try to request those records, work with the claimant to try to get the information they need. And oftentimes what happens, the insurance companies just say, oh, well, we waited 3 weeks, we're going to deny it. Right. That is so unreasonable. I mean, in my opinion, that's unreasonable. Right. Or the other option is written into every policy, we could send you to an independent medical exam. And I know we talk about independent medical exams and things that people should be aware of and concerned with those. But that's something else that they have available to them in order to determine that claim medically. And sometimes they just neglect to even do that. And they just say, you're denied. We're not going to bother with you. We're not going to even look at this any further.
What I see a lot of also is that a claimant goes ahead and sends in the medical records from 3 different specialists. Let's say they have a family medicine doctor, they have a neurologist, and then maybe they have an orthopedic doctor. And the disability carrier sends the records to a nurse practitioner to review them, or maybe they'll send it to I don't know, whatever their internal doctor is. Yep. And then they basically do nothing else with it. They just kind of like say, okay, we got the records, they maybe have their internal doctor look at it, and then they're done. They never do anything further. They don't go to the appropriate medical specialist. In my example, they don't have a neurologist look at the records, they don't have an orthopedic look at the records, and then they make a decision to deny the claim based upon that. And what the disability insurance companies are wrongly assuming is that just because they have someone look at the records, regardless of whether they're qualified or not, that's considered a thorough investigation. And that's completely unreasonable conduct if they engage in that kind of activity. So, they have a duty to properly evaluate the claim and to try to they can't put their own interests in front of the interests of the insured. Right. And when you start to look at the evaluation of how the disability company looks at the claim and you're saying, you know what, insurance company, you put your interests in front of the insured, and people looking in from the outside would say, you know what, that's not really reasonable conduct, that's when you have the opportunity to say, I probably have a bad faith claim here. Right. Other examples of bad faith that I've been seeing is, what about these companies that have these field rep interviewers who they send out to take statements? What's been your experience with examples of where a company sends a rep out and how that can result in some kind of bad faith claim?
Yeah, I had actually one particular time comes to mind when I had one insurance company send their field representative out. And my client traveled a long way to come here for this specific field interview. He didn't feel comfortable, obviously, having it done without his lawyer there, without me there. So we met with the insurance company field rep here, and the field rep started going through their typical questions, asking about the history of the claim, going through basically rehashing everything from the beginning. I didn't have a problem with that. I understand that they want to get responses from the insured. Sometimes they're looking also for consistency, whether the insured is going to be consistent with all the representations that they've made to the insurance company. But then he started getting into other things. He started looking through his tax returns and saying, well, so how much income did you earn from these gambling earnings? I was surprised. My client was surprised. He didn't know what he was talking about. He said, what gambling earnings? Yeah, these earnings here, it looks like they're gambling earnings. Casino earnings. It had nothing to do with that. It was some resort that he went to, for a continuing medical education trip that he had to take. And he started asking questions that, in my opinion, were completely inappropriate, pretty unconscionable, and unreasonable, to say the least. So that's one time specifically that this particular field rep had the gall to do this in front of the claimant and in front of his lawyer. Needless to say, the insurance company paid the claim, and they haven't bothered him since, after I wrote a stern letter to them just telling them how completely dissatisfied I was and really disappointed that they went to those extremes.
What I see a lot in the situations with a claim rep is the claim rep will come out to the claimant's home, take a statement from them, and then often either not give them any kind of notes whatsoever from the meeting, go back to their company, write a report about what the claimant said, and often between what the claimant actually said and what the person tells the company is a complete inconsistency. And based upon reliance on that inconsistent report from the field claim rep, the claim ends up getting denied. Another example I've seen is where the claim rep will come and write down a 2-page or 1-page summary of what the conversation was, and then the claim rep will go back and write a 7-page typed report and give it to the company. Then we know from our experience, we'll ask the company for a copy of the report, and they say no. Well, how do you expect the claimant to be able to verify the consistency of the statement that you're relying upon when you won't even show it to the claimant? Same way, like very often they'll take video surveillance and they won't even send it to the claimant, or they won't send it to the claimant's treating doctor. So, you know, the insurance companies need to conduct themselves in a reasonable manner so that if they deny a claim, they should be able to say, look, we gave the claimant every benefit of the doubt here. You know, we did everything we were supposed to. We took comment from everybody, and respectfully, we disagree with your doctors, or we disagree with whoever other witnesses that you may have. But if you don't thoroughly investigate the claim as a insurance company, then you've acted in bad faith. And again, not every state allows bad faith, and bad faith is actually a tort claim. It's like a negligence claim. It's a separate claim that has nothing to do with the contract, because when the company doesn't pay you, they're in breach of contract.
Right.
But when you bring a bad faith claim, that's a tort claim. And also many states require you to file a claim with the departments of insurance. Unfortunately, from my experience, many of the departments of insurance don't do very much to help the claimants because they're overwhelmed government entities, and unfortunately just don't have the resources to, you know, to help out these claimants.
Right.
So,
and I think it's also important to point out that in most states, in many states, you have to prevail on the breach of contract claim. In other words, you have to show that the company indeed breached their contract and that you are totally disabled before you can make any sort of bad faith recovery. Certainly, if you can't prove the breach of contract claim, you're not going to get the
right. And so what is a bad faith recovery? You know, the company acted in bad faith. Does that mean that you as a claimant get millions of dollars or automatically or something like that? No, it doesn't necessarily mean that. But what are the damages from a bad faith claim? And you know, those are difficult to, they're different in every case, because it's fact specific, but some of the elements we know are you get compensatory damages. Now, if your claim got denied and the company acted unreasonably and you prove a bad faith claim and you went into debt, you went into bankruptcy, or you lost your car, you lost your house, or you lost your whatever other things you had, you can claim that those were damages and articulate those damages and get money back for those kinds of things. Also, you know, you can get the emotional pain and suffering for whatever suffering you have as a result of that company not paying you, plus obviously the back benefits.
Right.
So those bad faith damages can be substantial, and then obviously we get into, do you reach the level of what's called punitive damages? And you know, from our experience of pursuing many punitive damage claims, especially in California, that raises it to a whole other level, and that's a penalty punishing the company to deter them from having this unreasonable conduct. And they're rare. It's very rare that you're going to see these punitive damage verdicts. I mean, we've seen verdicts around the country for $35 million, $60 million, $10 million. They don't happen all the time as much as the media would make it like, oh, another claim. They're very rare, but when they do happen, it's for very extreme, oppressive, unreasonable, malicious conduct that comes about from a disability insurance company.
And the other thing is that when speaking about damages, usually if there is indeed bad faith, if there's indeed unconscionable conduct there, most of the time these insurance companies, once they get into litigation with firms like us, you know, they realize that there's exposure and that there's liability, and oftentimes they dangle that carrot just high enough, and the clients tend to bite. So. Yeah. You know, it's one of those situations. I think that once you get to a certain point with damages, you have to really be able to establish the proof of those damages and where they're coming from.
I think it's, you know, every disability insurance company fears a bad faith claim, but you have to be cautious of, you know, not just throwing that out there if you're representing yourself, if you're a claimant, or you're with a lawyer who doesn't really know what bad faith is but holds himself out to be a bad faith lawyer. You don't tell the company you're acting in bad faith. You just don't do that. You have to prove your case. You have to know how to conduct the investigation, the discovery, especially if you're litigating, to show and prove that they acted unreasonably, because they're going to tell you all day long they did the right thing. And if you go along handling your claim and start throwing out the words bad faith to them, then you as the claimant are going to look like you're trying to set them up for bad faith. And you definitely don't want to have that situation, especially when you're the victim. You don't want to save them from their unreasonable conduct. So, on every claim, we certainly look into bad faith and try to protect a bad faith claim for every single claimant to investigate if it's there. More often than not, it's not there, but if it is there, we certainly know how to prove it, protect the claimant, get them the damages they're owed, and also seek punitive damages if that's necessary. So if you have a disability claim that's been denied, or whatever stage you're at, especially if you are considering litigation or feel that your claim's been unreasonably denied and you may have a bad faith claim or a claim for punitive damages, feel free to give us a call. We'll review your claim, provide you with a free consultation, and we're going to let you know right away whether or not we can assist you.